Everyone, and welcome to our webinar on handling common contract disputes and protecting your business's interests. My name is Paula Kumar, and I'm a practice leader in the disputes team at LegalVision. Before we begin, just a couple of quick housekeeping items. So you'll receive the recording and slides in your email. If you've got any questions at all, then just submit them in the Q&A box and we'll answer them at the end. And then if you could please complete the feedback survey after the webinar, that would be really appreciated. By viewing this webinar, you are eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. To claim your complimentary consultation, you can leave your contact details in the survey or you can contact us via our website. So now we're just going to have a look at the webinar. Before we do that, we're going to do a poll question. When it comes to contract disputes, we want to know what your biggest concern is. So is it losing money after a breach of contract? Is it chasing unpaid or overdue invoices? Dealing with a supplier or customer who's not delivering? Is it wanting to exit a contract without making it worse or getting ahead of problems before they spiral? Is it all of these things, or you're not sure, you're just here to learn? If you could select the one that is your biggest concern, then that would be really helpful to us. We'll give you a minute or so to do that. So the biggest one is all of the above. So that's great that you've come to this webinar, because we're going to be talking about all of these issues which arise in contracts. So just going through the agenda first, we're going to be looking at the most common types of contract disputes, which are breach of contract, payment disputes, performance failures, and contract termination. And then we're going to be looking at how you can potentially prevent those disputes from happening and, try and avoid derailing your business and focus on some kind of practical solutions. So the first topic that we're going to be looking at today is breach of contract, and understanding what the different types of breach there are. So the biggest one is the material breach. So this is a fundamental failure, and it goes to the contract's core purpose. So for example, a software supplier might deliver a system that can't perform the primary functions, and this is going to allow you to terminate the contract and claim damages if there has been a material breach. We also have a minor breach. So this is where performance falls short, but the essential purpose of the contract is still fulfilled. So for example, a delivery occurs a couple of days late, but the goods are still correct, and the delay causes no additional costs. So in that scenario, the contract is going to continue, but you might still be entitled to compensation if there is any shortfall at all. The third type of breach is an anticipated breach. So this is where there's a clear indication from the other party that they're not going to perform the contract. And this might be a contractor stating that they can't commence work due to capacity constraints. This actually allows you to treat the contract as if it's been terminated and seek alternative arrangements immediately. So what are your legal rights when a breach occurs? So the first one is damages, and this is compensation that's In a breach of contract scenario, it's designed to put you in the position you would have if the contract had been performed properly. So it's got to be a foreseeable loss. It can't be too remote, and it must be genuinely caused by the breach. Specific performance. This is another legal right that you have. It's a court order that requires actual performance of contractual obligations. So therefore it's normally available where there are unique goods or services where damages would be inadequate. Termination. This is obviously the right to treat the contract as ended and pursue damages for non-performance. It's important to remember that you, in any of these scenarios, you still have a duty to mitigate, which means that you have a legal obligation to take reasonable steps to minimise your losses. You can't simply allow damages to accumulate if there were reasonable alternatives which exist. Effective loss recovery strategies. So there are limitation periods for the different types of claims. For a breach of contract claim, it's typically 6 years. You've got to, in any kind of claim litigation, you always want to make sure that you have comprehensive documents. So this means preserving all your emails and contractual documents. If there are alternative suppliers and you've actually had increased costs, then make sure you are obtaining quotes for those. You might have photographs of defective goods or the incomplete work. And another one is to also maintain any record of time spent or additional expenses incurred. So those are all the types of documents that you really want to ensure that you maintain if there has been some sort of breach of contract. Calculating your losses. This is where you're looking at, your direct losses, the additional costs that you've actually incurred. There might be some consequential losses, and these are things like loss of profits or business opportunities, which may or may not you might be able to claim if they should be foreseeable losses. Other incidental expenses could be things like storage costs, staff overtime, professional fees. And in all of this, you want to consider a commercial settlement. So this might mean accepting less than your full entitlement, but that's going to save time and legal costs essentially. If we look at a more kind of strategic approach to breach resolution, the first thing is to always give formal notice. There is normally, within a contract, there's a provision that requires you to give notice. And this is really giving them the opportunity to remedy the breach. And it demonstrates that you're taking a reasonable approach and that you're kind of satisfying those requirements under the contract. And that's often more effective than taking any immediate legal action because it can achieve resolution. Again, you want to, in terms of kind of keeping documents, contemporary records are going to carry a lot more weight than reconstructed accounts later on down the line. So ensure that you're always keeping those records. And early legal advice is always going to help you evaluate, not just the strength of your position and the likely recovery, but also the strategy that you should take in a matter and how you should try to reach resolution. Got a little case study here, and here is an example of a breach of contract matter where a corporate conference has been booked for an annual client summit. The contract value is around 18,000. And the event's been planned well in advance for substantial 200 key clients with there's catering, speakers, and promotional materials. But then 6 weeks before the event, the venue cancels due to a double booking with a larger conference. And in this case, the company's going to incur additional costs. The only available alternative venue is for 28,000, so they're incurring an additional £10,000. They're also having to reprint promotional materials, which has resulted in an extra £1,800. And also staff overtime for reorganising the event, which is around £2,000. Some legal challenges here. So the venue's terms might attempt to exclude consequential losses. And there's a dispute over whether extra costs were actually foreseeable. The venue argues that the company should have had some kind of contingency plan. In this case, there's a resolution process where the parties have tried to spend some time negotiating, spent a few months doing that, and eventually it resolves at mediation. And the final outcome is £8,000, so about half of the additional costs. And the key lesson here is really to make sure that you check liability exclusions before signing, and not after problems arise. So even where you're winning a case, it can result in a partial recovery and significant time and investment and legal costs are still incurred. The next type of really common dispute is a payment dispute. The business reality of this is that, it's one of the most significant threats to a business's cash flow and growth. And you're effectively providing free financing. So you really need to ensure that you have strong contractual terms, and that, you are using a systematic collection procedure. And that's really essential for financial stability. So common dispute patterns that we see, quality objections. So, this is where customers raise performance concerns precisely at the time when a payment might be due. And this often, it might indicate a genuine issue, but the timing also suggests that, there's some sort of payment avoidance here. Invoice challenges, so a dispute over a previously agreed pricing or scope of work. And this usually stems from inadequate documentation of the agreement terms. Cash flow difficulties, so customer acknowledges the debt but claims that they are unable to pay immediately. And this can really create a precedent risk, and it also indicates deeper financial instability. Administrative delays are where a payment is lost because there is a very complex approval process or system. So it might actually be genuine, but it requires firm management to prevent this becoming a routine issue. If we look at some of the things that can be particularly effective in payment disputes, so late payment interest, this is 8% above Bank of England base rate, which is currently 12.25%. So that makes late payment pretty expensive for debtors. Retention of title clauses in your contract. This is going to ensure that you maintain ownership of goods until the payment is actually received. And that requires very careful drafting and, make sure that it is properly incorporated into your sale terms. There might be a right of set-off as well. So this is the legal principle which allows mutual debts to be offset against each other. So this can actually provide really valuable leverage in complex commercial relationships. But quite often we see that it's either not set out in the contract, or it might not even be mentioned. Another very useful procedure is statutory demands and insolvency processes, and this can be particularly effective where you have an undisputed debt. So in terms of being proactive for your payments, the first thing is obviously to ensure that you have really clear payment terms, and that is specifying the exact payment period and consequence of delay. So, payment within 30 days of the invoice date, and also specify the interest that be due on any overdue payment. Progress your payment structures. So you really want to avoid financing entire projects from your working capital. So, you might want to look at things like having a 25% deposit and then 50% on milestones and then 25% on completion, rather than waiting until the whole project has been completed, you've delivered all the services, and then the person doesn't pay up. Credit assessment procedures. So again, you might want to evaluate your customers' financial stability before you're extending some credit. And there's various ways of doing this. There's company searches, trade references, and also looking at credit limits based on their payment capacity. So what does that process look like in terms of recovering payments? So typically, day 1 to 7 after an invoice is due, you want to be making some sort of contact with them to confirm that they've received the invoice, and if there's any queries, you resolve them quickly. Then day 8 to 14, you're looking at a formal reminder attaching the documents to that email. Then day 15 to 21, a final demand letter actually saying what the consequences are of non-payment. And then beyond that, you might be going down either the statutory demand route or formal legal proceedings. Some additional advanced recovery techniques, so payment plans. So, if you have a client who's experiencing temporary difficulties, you might think about structuring an arrangement for those customers. Security arrangements, so these are things like personal guarantees, charges over assets, or retention title. Third-party debt collection, getting a professional debt recovery service for persistent cases. Or lastly, is legal proceedings where you're following the claims process for enforcing those invoices. Now we look at a case study for a marketing agency. So in this case, a digital marketing agency completed a campaign for property development client. The contract value is £25,000 for lead generation and brand development services. And this payment is withheld on the grounds that the lead quality was insufficient for clients' requirements. The weakness here in the contract is that there was actually no objective criteria for measuring lead quality or campaign success. So the outcome to this is recovery of £18,000, but there's been significant damage to the relationship, which has obviously drained resources as well. And the key lesson here is, you really want to have success metrics and payment triggers really defined in your contract in advance of this sort of situation happening. Which leads me on to performance failures. So, really trying to manage issues with suppliers or customers. So, performance failures, they often reflect communication breakdowns rather than a deliberate breach. And identifying those performance failures and intervening can really preserve a valuable business relationship, whilst also protecting your own interests. And, effective performance management creates competitive advantage through stronger partnerships. So it's really key. From a customer point of view, there's a need to kind of manage the scope. So you might have customers that are making unauthorized changes that impact the time and costs. So they might say something like, while you're working on this, could you also add this? And really, in that scenario, there should be that sort of request should come from a formal change control procedure that should be specified in your contract. The customers might also have obligations to provide necessary access and information, but there could be site access restrictions or delayed approvals or withholding information, and that can actually constitute breach on the customer side. And where we have these extended delays on decisions, that can also impact the project. Again, that's another customer obligation. And it's really their responsibility for providing accurate information and briefings. In terms of monitoring that performance, so some things that are really helpful, milestone-based reporting. So having a regular assessment point built into the contract structure. And this is going to prevent minor issues from accumulating into major problems. Some of the the key performance indicators might also be useful. And this is, you're really trying to have objective measurements of quality and the timelines and delivery standards. And that's going to remove subjective arguments from performance discussions, which is something that you really want to avoid having. You might also want to consider having an early warning system for potential delivery issues, and that's again going to allow proactive management rather than reactive problem solving. And also regular relationship reviews, so you're having a properly structured discussion about performance and how effective your partnership is. In terms of now looking at the framework for this, you might want to be following a formal notice procedure. So giving a written notice of any shortfalls with the performance and giving specific remedy requirements. And this is saying something like, this letter is serving as formal notice that your delivery standards are below the contractual requirements, and then setting out what those actually are. Within this framework, there's also normally a cure period. So this is a reasonable time allowance for performance improvement. And this is normally somewhere between 14 to 30 days, depending on complexity and the nature of the required improvements. There might also be a pre-agreed compensation amount for specific performance failure, and this is known as liquidated damages. And that helps remove uncertainty and disputes over damage quantification. Another very helpful mechanism is to have service credits. So, having an ongoing adjustment to reflect performance shortfalls. And this is really valuable because it can help maintain a commercial relationship whilst also giving some form of compensation. In terms of, preserving those relationships, so, try to have as collaborative an approach as possible, try to identify the issues together and the solutions, and have some flexible accommodation if there has been any changed circumstances. And if there is any need for improvement planning, make sure there is a structured approach towards that. So in relation to performance failures, I've got a case study here where an e-commerce business commissioned a custom inventory management system, which cost £80,000. It was supposed to be delivered within 6 months with full functionality for the Christmas trading period. But what actually happened is that it was delayed by 9 months. Lots of critical features are missing, and there are significant system errors. And the impact on the business has been £50,000 of lost sales during the peak season, additional costs for staffing. You've got a lot of issues in the contract with vague milestone definitions and nothing to kind of address giving a penalty in this situation. But in the end, you have successful resolution and you negotiate service credits worth £25,000. They're also getting priority technical support for 12 months and a free system upgrade. And this, one of the key benefits of this resolution process is that it has actually strengthened the support for any kind of future projects. The next type of very common dispute that we see is contract termination, how to exit a contract and, really what happens next in these scenarios. So termination is obviously, it's a significant business decision, and that's going to have legal and financial and commercial implications. And a proper termination procedure is going to protect your position and minimize exposure to claims. And understanding the consequences of termination is going to enable the business to make informed decisions about whether they want to continue or whether they want to end a relationship. A termination might become necessary. So this might be because of a material breach, which I mentioned earlier. So, despite there being a formal notice and opportunity to remedy it, failures continue. Um, there might be a fundamental change in business requirements, which just means that, continuation of the contract is just not commercially appropriate. There might be superior alternative arrangements elsewhere. So, you might get significantly better terms or performance available from another supplier. There could be a relationship breakdown. So trust and communication is going to have deteriorated. It's completely broken down. Termination becomes necessary. Neither side is trusting each other. Or financial instability. This is another very common one where termination is necessary because there's significant concerns about their ability to fulfill future obligations. Types of termination rights that we have for termination for cause. So this is the right to enter to end a contract due to the other party's material breach. And this requires really clear evidence of the breach and compliance with notice procedures, and it usually permits recovery of damages caused by the breach. Termination for convenience. So this is the right to end the contract without cause. Typically, there's a notice period here, and it generally requires payment for work that's been completed and reasonable termination costs. You might have automatic termination events. So these are really specific circumstances set out in the contract which trigger immediate contract end. So where somebody's become insolvent and there's been a change of control or some sort of material adverse change. Lastly, there's mutual termination. So both parties agree to end the contract early, and that's normally the cleanest exit because the parties are engaged in negotiated settlement of any outstanding issues. In this scenario, we have a software development contract termination example. So this was a 2-year custom software development agreement, which was worth £100,000. But there were a lot of performance issues, consistent missed deadlines, the poor code quality, and there was an inadequate response to feedback. So in this scenario, a formal performance notice is sent, but then there's a final catalyst, and this is the discovery of some very serious security vulnerabilities that are unreasonable. The contract allows the customer to terminate for cause in this case, and a new developer completes the project much more efficiently and to higher standards. Critical factors in this situation: comprehensive documents, making sure that you can prove that you have followed the notice compliance, and kind of any evidence of any resolution attempts as well is going to be useful in this situation. So in terms of termination process requirements, you want to be checking your contracts, make sure there are specific termination clauses and procedural requirements. There might be different notice periods and cure rights and procedural steps. And you also want to follow make sure that you have your documentation that's supporting the termination decision, particularly where there's cause-based termination. So, any kind of performance records or correspondence or breach notifications. And then you really want to assess the situation. So, understanding financial and the operational impact of termination. So there might be work in progress and outstanding payments and other costs. When you're looking at termination, you also need to think what's going to happen post-termination. So this is looking at, firstly, might be some asset recovery. So you want to ensure that any property is returned or documents or equipment, there's any confidential information. Those kind of obligations would hopefully would continue post-termination. So, confidentiality, IP, non-compete. You might also, you would also have to ensure that you have financial reconciliation. So making sure that any outstanding payments are paid by the termination date. And then you're also looking at transition support as well. So, having some reasonable cooperation. If you're moving over to a new supplier, you want to ensure that that handover is nice and smooth. Termination management, we're looking at best practices here. So, the first thing is to always consider alternatives first. If you can renegotiate or vary the contract, that's going to address issues without having to go through termination. Within all of this, make sure you are taking a professional approach. And it's very easy for things to become emotional, but you need to ensure that you're maintaining business standards even when a relationship has deteriorated. Keeping documents is really crucial if the matter ever does become litigious. And ensuring, you also have alternative arrangements before you terminate what might be a really critical service to the business. And lastly, take legal advice. Termination can be really complex, and you need to ensure that you're following the right process and considering the strategy. And lastly, we're going to look at dispute prevention. So these are some strategies that you could be looking at. Regularly measuring the performance and service levels, having structured review meetings to assess contract performance and identify if there are any issues. You could have quarterly operational reviews with key stakeholders. Also consider issuing an escalation procedure, so having a really clear pathway to address problems at the appropriate management level. And in this case, you could have operational issues that are resolved locally, but more strategic matters that are escalated to more senior management. In terms of having a risk management process, you could be looking at having a regular risk register update and make sure that you are assigning ownership to those people that are dealing with those. Feedback mechanisms, also really useful to have a regular channel for both parties to raise concerns and any suggestions. And this could be through an anonymous feedback system or a structured relationship survey. And also looking at trend analysis. So, identify if there are any performance problems and indicating any potential future problems. In terms of really trying to rapidly resolve these matters, direct communication is always going to be the best way forward. Having some personal contact to resolve issues before the formal processes. Picking up the phone, to somebody can often resolve a dispute without, if you go sometimes into email exchanges, written exchanges, it can become quite heated quickly. Having a structured negotiation, making sure that you've got clear objectives and that the people involved in that decision, in that negotiation actually have the authority to make those decisions. Mediation services also help you resolve matters really quickly, and this is where you're getting somebody to facilitate a mutually acceptable solution, and that's going to be significantly less expensive than litigation and can also preserve a commercial relationship. And then lastly, settlement discussions, formal negotiations that you're having with the other party, and there's also going to be some protection from those being disclosed if the matter doesn't resolve. In terms of looking at your contracts to prevent disputes from happening, so precise language is really key, and having some clear measurable terms that might minimize interpretation disputes. Trying to replace subjective terms like reasonable quality with an objective standard and measurement. We also like to have a milestone-based structure, so having payment and performance linked to a specific deliverable. Should also have a change control procedure. And so if there is any variation or scope adjustment, then there's a formal process for following that. And then having also a built-in review mechanism, and having regular contract assessment and any opportunity to adjust that. So the clear resolution procedure is really going to help, hopefully resolve the matter. So from the informal discussion through to formal resolution. And we're looking at really a cultural approach to prevention here and treating suppliers and customers as long-term business partners rather than adversaries. Try to have proactive communication, with regular contact, beyond operational necessity, and that's really going to improve your relationships. Um, Problem solving, really focusing on finding solutions rather than assigning blame when issues arise. And then continuous improvement. So, we're always learning, and we're learning from each challenge to try and strengthen future arrangements. If you've got a problem that's happened in this contract, let's see what we can do to prevent that happening again and address that in your contract. And then, keeping and maintaining professional standards. So, even when you're involved in a relationship that's become strained, you want to ensure that the interactions are still professional. So looking at our essential takeaways here. So from a business perspective, contract disputes are primarily business relationship challenges and they require commercial solutions. And within all of that, I've said this many times, document discipline, keeping documents is really essential for resolving disputes and recovering losses later down the line if necessary. Having a contract management procedure also, is going to prevent more significant problems. Intervening early, we really want to try and address issues before a formal dispute resolution procedure is actually started. And then just really investing in your relationship. Strong business relationships can survive disputes and they can often emerge stronger from effective problem solving. So that concludes the main part of our webinar. You might find our publication useful, which is our guide to resolving UK business disputes, which is available in the resources tab or by scanning the QR code. You might also be interested in our upcoming event, which is Managing Stress and Workload, Employer Responsibilities under Health and Safety Law. We're going to answer your questions shortly. If you've got any questions, then please submit them. While you're doing that, we'll just take a minute to talk to you about LegalVision's membership. So by becoming a LegalVision member, your business is going to get unlimited access to our full team of specialist lawyers for all your business as usual legal needs, which is very much like having your own in-house counsel for a fraction of the cost. And our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more than this as well. So as a LegalVision member, you don't have to worry about the cost of lawyers again. We can also help you with any busy, high volume business as usual legal tasks. If you want to learn more about membership, then you can request a free consultation when the survey appears at the end of this webinar. So now we're going to look at some of the questions that have been coming through. The first one is, when translation suppliers consistently undeliver on quality and turnaround times, termination can disrupt client projects. How should LSPs try to legally exit underperforming vendor relationships without incurring liability? So here you're experiencing real challenge because you've got demanding clients and unreliable suppliers. You want to ensure that you build in performance standards. So, trying to avoid that subjective language that I said, like having high quality, reasonable quality, have a specific measurable metric, something like 98, 99% accuracy rates. Delivery's got to be within, 24 hours. Any kind of specific formatting requirements as well. Have cure periods as well, to ensure that, you're not being unreasonable. You could also have, you want to have the termination clause, for convenience as well. So, if there's a provision which allows you to exit a relationship without having to prove that there's been a breach, it might be an insurance against that kind of situation. The next question that we have is, how do you handle disputes where client refuses to pay despite clear contract compliance? So there's a couple of different options here. If there's genuinely no dispute over the matter, then you can use a statutory demand procedure, which is really effective. You give them 21 days to pay up, and if they don't, then you have the threat of being able to wind up their business. So it's a very useful procedure. If there is a dispute, then you can't follow the statutory demand route, but you need to ensure that you do follow a kind of formal process. So, that's following if you followed the kind of dispute resolution process within your contract, if you have one, or otherwise it's, sending a letter of claim, and, kind of following that process. And if you do end up having to go to court, then issuing a claim and going through that procedure. Next question that we've had is, what are the issues around specific performance? So this is a remedy that, a lot of people do want, but it's actually very rare. Courts are going to prefer to award damages in commercial contexts. And this is because, courts aren't going to want to force people to perform obligations. You can only really get it where damages are inadequate. So, in most business problems that happen like this, money is going to fix the problem. So, courts are going to say that that is the best approach in those matters. So it is actually quite a difficult procedure to take. But what you can think about, if there is a situation where, you've got a unique service, replacement supplies are not available, or the service has some kind of ongoing value that's hard to quantify, then, specific performance might be available in those situations. But that's, really the extent of where this kind of remedy is going to be awarded. Okay, another question that we've had is, how do you recover losses effectively? The key thing here is to maintain documents, and understanding what your loss is. So, there are various different losses, which I explained, direct losses flowing immediately from the breach. So that's, unpaid invoices, things like that. But then, there are consequential losses, such as lost profits. But those losses can only be recovered where it was reasonably foreseeable, at the time that the contract was actually formed. So, this is why a lot of contracts actually include specific categories that the parties acknowledge as being foreseeable, and also set out what types of losses are not actually subject to recovery. We've got time for one more question. How do you handle contract issues with no written contract, any emails? So, the good thing is email contracts are still going to be legally valid. So, it doesn't have to be a formal agreement for it to be a formal contract. The challenge is going to be in evidence. So, you might have email chains which describe what the services are, and but there might not be things built in within that, such as termination. You might say these are the services that I want, this is when I want it to be delivered, but nobody's thinking at that point about what termination route might be accessible if the contract is actually breached in some way. So the evidence and the route that you take to resolve that situation is more complicated. But it's still the same principles. You still got to offer acceptance and consideration and intention to create that legal relationship. And the court is going to be looking at that when they're looking at the entire process. So that's all the time that we have today. Sorry if we haven't answered your question. You can submit your details in the survey at the end. And if you want to learn more about our membership, then feel free to get in touch with us. Whilst it's a free webinar, we really value your feedback. So if you can complete the survey at the end, it only takes about 30 seconds. So, but thanks very much for joining us, and look forward to speaking to you again soon.